A very good afternoon to everyone present here today. If the judges are ready, may I begin?
Yes, you may. Wow.
All right.
Ganti.
The High Court of Malaya at Kuala Lumpur is now in session. The case before the court is the matter concerning Dr. Bashir bin Shakir as the plaintiff and University Hadari Malaysia, UHM, and the Government of Malaysia as the defendants.
May it please this court, my lords and my lady. My name is Stephanie Robert Mangharam, and I will be appearing on behalf of the plaintiff, Dr. Bashir bin Shakir. Appearing with me, my co-counsel, Ms. Kam Kayen, and my learned friends, Mr. Ajron and Mr. Melvin Ng, will be appearing on behalf of the defendant, the University Hadari Malaysia, and also the Government of Malaysia. I will be submitting on the first two grounds. First being, the first disciplinary charge against the plaintiff has violated his rights to freedom of speech and expression. Second being, the second disciplinary charge against the plaintiff has violated his rights to personal autonomy, while my co-counsel, Ms. Kam Kayen, will cover the third and final grounds, which are the denial of the plaintiff's request during the disciplinary proceedings have violated the principles of natural justice, and the arrest of the plaintiff under the emergency law suffered from illegality and procedural impropriety due to ineffective of the emergency ordinance. I'll be submitting on the first two grounds for 17 minutes, while my co-counsel will have 16 minutes to submit her grounds, and we will be reserving 2 minutes for rebuttal. Before I begin my submission, should I present to my lord and my lady a brief summary of the facts of the case?
I don't find it necessary unless my fellow judges require it.
No, thank you.
No, thank you.
Much obliged. I may begin with my submission, my lords and my ladies. I will first submit on the first ground, which is the first disciplinary charge against the plaintiff has violated his rights to freedom of speech and expression under Article 10(1)(a) of the Federal Constitution. I have 2 points to support my contention. First point would be Regulation 18 of the Statutory Bodies Disciplinary and Surcharge Act 2000, hereinafter, Act 605, is inconsistent with the Federal Constitution, and this can be found in page 7 of the plaintiff's memorial. On 3rd of August 2021, disciplinary charges were served on a plaintiff under Regulation 35 of Act 605. We submit that Regulation 18 of Act 605, which prohibits an officer from making public statements, comments, circulates a statement that would potentially embarrass, be detrimental, or bring disrepute to the statutory body or government, should be declared as null and void for unreasonably restricting the rights to freedom of speech and expression under Article 10(1)(a) of the Federal Constitution, which states that every citizen has the rights to freedom of speech and expression. When it comes to
Counsel, you're not at all going to take the point that the university is not a statutory body?
the university is not a statutory body, but the government is, my lord.
No. He's being disciplined. Dr. Bashir is being disciplined under the Statutory Bodies Discipline and Surcharge Act, right? So are you not at all going to attempt the arguments that the university is not a statutory body, bearing in mind the interpretation of a statutory body under Section 2 of the Act, bearing in mind that there is a Section 5A of UUCA? Are you not even going to attempt that point? Are you giving up on that point totally from the start?
No, my lord. That point would be on the second ground of our submission. On the second ground. May I proceed, my lord?
On the second ground, are you sure? All right, we'll wait for the second ground then. Proceed.
We submit that Regulation 18 of Act 605, which prohibits an officer from making public statements, comments, or circulate statement that would potentially embarrass, be detrimental, or bring disrepute to the statutory body or government, should be declared as null and void for unreasonably restricting the rights to freedom of speech and expression under paragraph A of Article 10(1) of the Federal Constitution, which states that every citizen has the right to freedom of speech and expression. When it comes to paragraph A of Article 10(1) of the Federal Constitution, it is subjected to restriction that is laid down in Article 10(2)(a) of the Federal Constitution, which authorizes Parliament to restrict freedom of speech on 8 grounds, namely national security, friendly relations with other countries, public order, morality, incitement to any offenses, defamation, contempt of court, or privilege of the parliament. But in our context today, my lords and my ladies, public order and morality will be of relevance. I shall speak first on legality. As rightly put in the...
Sorry, before you go on, wouldn't the public health, wouldn't you regard that as an extension of the public order?
Yes, my lady, public health. But I will proceed by saying that the plaintiff was securing public order in a way that he is an expert medical professor, and he in turn would be preserving public order, my lady.
Proceed.
But Dr. Bashir was disciplined as an employee. And these are rights afforded to him as a citizen. He was not disciplined as a citizen, but he was disciplined as an employee in the context of his employment. Now, surely, right, in light of Tan Sri Nordin's case concerning UUM, affirming Rosalind O, affirming Kana Wagi, surely an employee would be governed by regulations and would be subject to discipline, notwithstanding his fundamental liberties as a citizen.
Yes, my lord, but here he was also a president of the ASA, and also he was spreading his opinion based on his capacity as a president of ASA and also a medical researcher, my lord.
But do you accept as an employee, he would be bound by the necessary policies and regulations in place? He has to adhere to them, irrespective of personal views.
Yes, my lady, I see that. But I shall proceed with my our summation would be that he is expressing his points and his views as a capacity as a medical professor and also a president of the ASA, my lady.
That doesn't seem to be answering the question, that he is subject to disciplinary proceedings as an employee, regardless of his rights as a citizen.
In other words, you cannot look at it in isolation. Right now, you are saying, close your eyes to the fact that he's an employee and he's subjected to it. Firstly, do you accept that as an employee, he is bound to adhere to such regulations and policies?
Yes, he is bound, my lady. He is bound by the regulation under Regulation 18 of Act 605.
Yes,
But
carry on, sorry.
Because Regulation 18 of 605 should be unconstitutional because it violates the plaintiff's rights to speak on because it goes against public order, my lady.
How can that be said when he's expressing views contrary to the circulars or policies in place within the institution?
The circular itself is already a violation of personal liberty, my lady. So
you're saying that there was no basis or right to issue such circulars?
No, the federal constitution is the main it will be supreme in this case, Melody, which would mean that Regulation 18 is going against the fundamental liberties and the federal constitution.
But taking your points to the extreme, then every employee can do anything they like, say anything against their employers because it is part of their freedom of expression. There will be a total breakdown of employer-employee relationships.
But because of plaintiff's capacity and qualification as a professor and a renowned medical researcher, should be the exceptions that he should fall under. Sorry, much apologies, my lord.
Sorry, I don't follow your argument. What exception? Because you accept that he's an employee. He is bound by those policies, circulars in place. So what exception would there be for him to make these statements which are in contradiction or total violation of what is already in place, which has been set by his employer?
The Regulation 18 restricts the I'm sorry, my lady, I shall rephrase that. When it comes to paragraph A of Article 10(2)(a) of the Federal Constitution, it authorizes Parliament to restrict freedom of speech on 8 grounds, and only those 8 grounds, namely national security, friendly relations with other countries, and includes public order and morality, my lady.
So a private employee, for instance, can say anything they want against the employer, and there will be no disciplinary proceedings ever possible because it is their constitutional right for freedom of expression. Is that the position that you are advocating?
Now we're saying that the plaintiff is bound to the rules of their employers.
If they are bound by the rules of their employers, then surely the disciplinary action is proper.
Maybe okay, my lord, maybe I should proceed with my grounds. Maybe there would be an answer from that question. I'm so sorry, I couldn't help the court with this answer, my lord.
All right. Proceed then.
Much obliged, my lord. My lord and my lady, even though Dr. Bashir is a public officer, he is also an academician. A distinction must be drawn between the nature of work of an academician and a regular officer of a statutory body. An academician's work is an academician is defined as member such as professor on an institution of learning, such as the university, and the plaintiff clearly falls under this category. Unlike a regular officer of a statutory body, an academician's work is not confined to merely exercising function of an office for the benefit of the public, but it is meant to improve or maintain standards in a particular field. Regulation 18 of Act 605 does not make this distinction, which results in unreasonable restriction being imposed upon academicians, and it is disproportionate to the purpose of the academician's work. Therefore, my lord and my lady, I would conclude that Regulation 18 should be declared as null and void for unreasonably restricting the plaintiff's rights of freedom of speech and expression under Article 10(1)(a) of the Federal Constitution. I shall now proceed with point number 2 of my first ground, which would be the plaintiff's expression of his fears, of suspicion, and opinions of the COVID vaccination does not fall under the scope of Article 10(2)(a) of the Federal Constitution. This can be found in page 9 of the plaintiff's memorial. Article 10(2)(a), as mentioned previously, authorizes Parliament to restrict freedom of speech on 8 grounds, which includes public order and morality. The plaintiff's expression of his fears, suspicion, and opinions of the COVID vaccination does not fall within these ambits of this article. In fact, he was preserving public order and morality. The plaintiff in this case, who is a renowned medical researcher, was providing his expert opinions by expressing his suspicion regarding the COVID vaccination. Therefore, his expression does not fall within the scope of Regulation 10(2)(a) of the Federal Constitution. In the case of
being bound by regulations, he could have used proper channels. For example, by escalating his views internally or expressing his views even directly to the government. Surely he could have used proper channels instead of going public with it.
Yes, I acknowledge the concern that public health may be compromised, or because of his ways of the plaintiff's ways of expressing his opinion, but it is a need for the society to understand and know about the COVID vaccination by from the plaintiff himself in deciding whether they should be a proponent or an opponent to the COVID vaccination, my lord. In the case of Muhammad Hilman Idham, it was also ruled that
sorry, we've read your submissions. I know you have placed reliance on Muhammad Hilman's case, but that was pertaining to a student who expresses support for the opposition, which could not be seen to bring about an adverse effect. But this is distinguishable, isn't it? It's a healthcare professional. His views are going to be taken into consideration by the general public. And by making these statements, would that not create confusion or chaos within the public and thereby jeopardizing public order?
Yes, my lady, but I have stated before that he is an academician, so he should have the capacity to express his fear as a medical professor. So the COVID vaccine about the COVID vaccination, and it does not. It doesn't. It is actually. It does not bring about an adverse effect on public order and morality. The plain
Such statements, you are saying, will not bring about this public disorder,
yes.
negative criticism, and so forth. It's not going to bring that about. That's your submission.
That is my submission, but the society has the rights to know and understand about the COVID vaccination due to his capacity and his qualification as a medical, from his capacity and qualification as a renowned medical researcher.
I think my learned
Go ahead.
sorry, my learned brother had put that question to you earlier, which you did not quite answer, I think, and you're not answering it now as well. How do you balance that against the fact that he remains an employee and he's governed by these circulars? There were other avenues for him to take it up and so forth. You still not address that?
Maybe I wouldn't be able to understand my lady's question. Wouldn't be able to answer my lady and my lord's question. I couldn't. We didn't research on that matter. I'm sorry, my lady.
All right, that's fine.
Much obliged. The plaintiff was aiming to ensure public order and morality through organizing online seminars with international anti-vaxxers group, and he strongly believed that subjecting the Malaysian population with such irresponsibly prepared vaccination is detrimental to the well-being of the public. So I would like to conclude my submission by saying that that the second disciplinary charge against the plaintiff have violated his rights to personal autonomy, which brings, I'm sorry, my lady. I would like to continue with my second ground because of the restricted time that I have, my lady and my lord. My lord and my lady, I would like to proceed with my next ground, which is the second disciplinary charge against the plaintiff that have violated.
Are you asking for additional time? Because I didn't hear you ask for additional time. Are you asking for additional time?
We are not. Yes, I'm asking for additional time, my lord.
2 minutes, perhaps, for you to sum up your points.
Just to sum up my submission, my lord.
Yes.
Thank you. Much obliged. My lord and my lady, I would like to end my submission by saying that although I acknowledge that the concern of public health that may be compromised by the plaintiff's opinion, however, my lady, there is a need for society to know and understand the effects of vaccine before subjecting themselves to the vaccination. To decide on their own whether they should be a proponent or an opponent to the COVID vaccination. So the plaintiff's opinion is crucial in aiding people's decision-making process. Therefore, my lord and my lady, I would like to conclude my first ground by saying that everyone's fundamental rights laid down in federal constitution are not absolute, and the plaintiff should be given his rights to freedom of speech. I can safely say that the plaintiff's freedom of speech have been encroached by the university, and I would like to, may it please this court, I would like to allow my co-counsel to submit on the third and final grounds.
Before I begin, may I know if I'm audible to this court?
You are to me.
Much obliged. May it please the court, my lords and my lady, my name is Kampayan, and I appear as the co-counsel for plaintiff. My submission shall concern two grounds. First, being the denial of the plaintiff's right to oral representation is a violation of principle of natural justice. Second being, plaintiff's arrest and detention under Section 17 of the Emergency Essential Powers No. 2 Ordinance 2021 has suffered from illegality and procedural impropriety. I reserve 16 minutes for my submission. My lords and my lady, on the third ground, we submit that the denial of the right to oral representation with expert witnesses is a violation of the principle of natural justice.
Why do you say that when he has already been granted the right to a written representation?
My lady, to answer my lady's question, the answer is that oral representation shall be given in serious cases where its consequences is a dismissal from work. My lady, referring to a federal court case, Dr. Lourdes Dalva and Dr. Milton decided in 2020, it has affirmed that a person ought to be accorded the right to be heard in his own cause, a fair hearing, and opportunity to defend himself against the charge proffered against him. And
all right, you started off saying shall be accorded a right, and then you use the case to say ought to be given. So those two are worlds apart. So
my lady,
what is the premise for saying he has to be given a right to an oral hearing?
My lady, we agree that the right to be heard does not in all cases include the duty to afford an oral representation. However, we aver that the nature of the alleged charges and the consequences that it may entail, which is either dismissal or reduction in rank, an oral representation is vital, for otherwise the fair hearing safeguard under Article 135, Clause 2 would lose its significance and purpose as a constitutional right. Does my answer? Yes, much obliged, my lady.
But Ms. Kam, Dr. Lut's case is one where there was no service of course papers at all, compared to this particular case where he was given a right to give, albeit a written representation. And Article 135 is for specific services, which does not include a lecturer. Isn't that correct?
To answer my lord's question, we would like to respectfully disagree because according to 135 clause 2, it says that plaintiff is actually rightly protected under Article 135 clause 2 because he is part of the education service protected under clause 130, Article 132 of the Federal Constitution, my lord.
But then even if he's protected, then Yusuf Sudin's case says oral hearing is not compulsory, isn't it?
My lord, to answer my lord's question, we would like to refer my lords to the case that my lord has just mentioned, Yusuf Sudin, where the federal court judge Zulkifli actually referred to a book titled Disciplinary Proceeding Against Public Officer in Malaysia, written by Dr. Gan Cheng Chuan, a former associate professor at the Faculty of Law, University of Malaya. In that book, the professor stated that the nature of an accusation and the consequences of it is an added factor to support for that proposition that an oral hearing has to be given to the affected officer, my lord.
Would you accept that by giving him the opportunity?
Much obliged, my lord.
Sorry, would you accept that by giving him the opportunity for a written representation, there has been no breach of natural justice?
To answer my lady's question, we agree to a certain extent because in this case, it happened during COVID-19 pandemic. Therefore, we submit that perhaps plaintiff has been given the right to be heard by way of written representation. But during COVID-19, we strongly believe that an oral representation is much needed, especially when the charges against the plaintiff would lead to a consequences where he could either be dismissed or reduced in rank. And this would affect the plaintiff's livelihood and this would affect the plaintiff's reputation and livelihood and livelihood. Answer my lady's question. I hope I answer my lady's question.
How does the fact that there is a pandemic strengthen your points that you need oral representation? How does it? I mean, it sounds contrary to logic to me. All the more in a pandemic, you should rely on written representations rather than to hold oral hearings.
To answer my lord's question, we submit that, especially in trying times back in 2021, where economic fallout from COVID-19 has hit almost every Malaysian household. And by way of just written representation, it would not help the plaintiff it would not sufficient for plaintiff to explain himself, because he will not be able to speak to the disciplinary committee and also bring in expert witnesses to further corroborate his opinion that he could be right. Therefore, giving merely just a written representation, it would not be sufficient for the plaintiff to fully exculpate himself.
Does the fact that his opinion may be right justify a breach of Regulation 18?
Could my lord repeat your question?
Does the fact that his opinion could be right? He has got a view, maybe it is a correct view, that the vaccines are not properly developed. Could the fact that his opinion could be right justify a non-compliance to Regulation 18?
To answer my lord's question, could I have a moment to gather my thoughts, my lord? My lord, to answer my lord's question, it could be justified because as what my co-counsel has mentioned earlier, COVID-19 plaintiff, it was a renowned medical researcher. He has the capacity to tell the public that whether COVID vaccination is proponent or opponent, and therefore we would like to also submit that we were all once afraid of getting vaccinated, but as plaintiff, as a renowned medical researcher, it is reasonable for him to express his fear and suspicion. And with that, with that, we also would like to support that plaintiff is not a layman person. If a layman person like me publish a public statement saying that the vaccination is not safe, then it would have go against the Regulation 18. But as a renowned medical researcher, the plaintiff it is reasonable for plaintiff to express his opinion, and therefore we submit that it doesn't go against Regulation 18 of the Statutory Bodies Act.
On the contrary, if a layman expresses his opinion, nobody cares. But when the plaintiff expresses his opinion, then it comes with substantial impacts to society. So he has more responsibility and more obligation.
My lord, we agree, and we agree to my lord's view. However, we believe that the society has the right to know whether the vaccine is truly effective or not. If imagine that a renowned medical researcher like plaintiff, like what my lord has mentioned, he has the capacity and influential, and therefore he has the capacity to tell the society whether vaccine is needed or whether the vaccine is effective or not. If in the event someone influential like him did not make a public statement, the public wouldn't have know whether the vaccine is safe or not, and then it would even cause more harm and detrimental. It would even cause more harm and detriment, my lord. Much obliged, my lord. Moving on to my second point, we would like to submit that the denial of right to oral representation with expert witnesses is a violation to principle of natural justice. As I've mentioned earlier, my lords and my lady, it is undeniable that we were all once afraid of getting vaccinated. But plaintiff, as a renowned medical researcher, he has the reasonable capacity to express his opinion. And in fact, there is no evidence in this world that can prove the vaccine is 100% free. My lords and my lady, the reason why we submit that it cannot be written in a written representation is because the disciplinary committee would have difficulty in understanding medical terms from expert witness. Therefore, bringing expert witnesses before the disciplinary committee would help to corroborate his opinion and also to ensure that the committee has all the information before making a decision to dismiss or reduce his rank, my lord and my lady. My lords and my lady, it is also not our intention for the court to seek the court's interference with the nature of punishment, but the process of the disciplinary proceeding for failing to provide a fair hearing that renders the dismissal of plaintiff null and void. Should I be no further assistance to the court, may I begin with my fourth ground? Much obliged, my lord and my lady. Moving on to my fourth ground, being that the plaintiff's arrest and detention under Section 17 of the Emergency Ordinance Essential Powers No. 2, 2021 suffered from illegality and procedural impropriety. We have 2 points to make, and the first is that we submit that plaintiff's arrest and detention under Section 17 of this emergency ordinance had ceased to have effect. My lords and my lady, as stated in para 12D, Roman number 1 of the Moot problem, the Minister of Law had made a statement that in Parliament that the emergency ordinance had been brought to an end by Cabinet and therefore ceased to have effect from 21st July 2021. If I may
Is a mere statement sufficient to revoke the emergency ordinance?
To answer my lady's question, if I may bring the court's attention to a case of Tai Cheng Po and public prosecutor, where it held that when the constitution itself or in federal law powers confer upon the Yang di-Pertuan Agong that are expressed to be exercisable if he is of his opinion or upon his satisfaction, this would mean that it refers to the collective opinion or satisfaction of the members of parliament. And in this case, bringing an end to the emergency ordinance was a decision by the cabinet. This is a reflection of the YDPA's view because Article 150, Clause 2B states that an emergency ordinance can be promulgated upon his satisfaction.
You're not answering my question. I asked you whether a mere statement saying that it has been brought to an end is sufficient.
My lords,
a mere statement that was made.
My lady, I would like to answer my lady's question. Yes, but to a no, but to a certain extent. This is because, as stated in the case of Tai Cheng Po, if the cabinet has satisfied, if the cabinet opines that the emergency ordinance has been seized, it is also reflect to the YDPA view that it is also reflected in the YDPA's view that the emergency ordinance had been seized. This is because
Parliament is not necessary at all. Parliament is totally unnecessary. From cabinet, whatever cabinet decides is reflection of the king's views, and that's it. Is that your submission?
To answer my lord's question, if it is an act of parliament, if it's a bill, then perhaps parliament, of course, is very important because you have to pass the law by the parliament. But in our case, it is an emergency ordinance. An emergency ordinance does not require the parliament to pass it. It is totally up to the YDPA to promulgate it.
Let me put it this way. So are you saying the revocation done by way of this statement is in accordance with constitutional law?
Yes, according to Article 150, Clause 2C, reading together with Clause 3 and 7 of the Federal Constitution, there are 3 ways where an ordinance could be seized to have effect or unenforceable. And one of the ways is that when it is revoked by the Yang di-Pertuan Agong. And we submit that because the cabinet opines that decided that the emergency ordinance should be seized, and it reflected in YDPA's view, and it also reflected in YDPA's view, it is revoked by this way.
Wasn't there an announcement? It was put in the submissions of your learned friends that the king, the palace, in fact, disavowed the statement by the minister.
To answer my lord's question, that is purely an assumption because it is not written in a moot problem.
No, the disavowal is public knowledge, surely. You don't have to write that into a moot problem, right?
To my lords, I see my time is up, but could I ask for an extension of time to answer my lord's question?
Of course.
To answer my lord's question, I believe that the moot problem should be what we should be adhering to the moot problem. If the moot problem has not stated that the king has showed dissatisfaction or disallowed the emergency the cease or disallowed the emergency ordinance to cease to have effect, we should not take that into account for this case, my lord.
So sum up, please. Yeah.
Much obliged, my lord. I see that I could not have no time to continue with my second submission. So I would like to ask if should I continue, or I would just like the court would just like me to sum up my submission.
I think just sum up, subject to my fellow judges.
Much obliged. We respectfully request that this High Court to declare that first, Regulation 18A, B, and C shall be declared violating Article 10, Clause 1A of Federal Constitution. And second, the University Circular dated 23rd December 2020 and Vice Chancellor's reminder dated 26 December 2020 be declared for violating Article 5, Clause 1 of the Federal Constitution. And third, plaintiff's dismissal to be set aside because the proceeding was violating the principle of natural justice. Fourth, the Emergency Essential Power Number 2 Ordinance 2021 had ceased to have effect from 21st July 2021. And lastly, plaintiff's arrest and detention under Section 17 of the Emergency Essential Powers Number 2 Ordinance 2021 has suffered from illegality and procedural impropriety. I thank the court for its time and indulgence. Much obliged.
Thank you, Counsel.
My lords and my lady, can I please check if I'm visible and audible?
Yes to me.
May it please this honorable court, my name is Arjun Amraj and I appear before this court today on behalf of the defendants, University of Hadrari, Malaysia and the Government of Malaysia. Together with me is my co-counsel, Mr. Melvin. This is a case brought by the plaintiff who had uttered words and phrases that had disrupted the efforts of the defendants, the university and the Government of Malaysia in curbing the spread of the coronavirus, yet claims to be protected by his constitutional right to freedom of speech. The plaintiff, who had also blatantly disregarded the instructions by the defendant to not continue with his anti-vax seminars and had completely ignored the Vice Chancellor's written reminder to refrain from making any public statements that are detrimental to the policy of the university or the government. The plaintiff's own inconsiderate actions had detrimental consequences upon him, and he was subjected to disciplinary charges. His own actions were also what had brought upon his arrest. As such, there are four main issues before this court today. Firstly, whether the plaintiff's application of Regulation 18 was a violation of the plaintiff's constitutional right to freedom of speech under Article 10, Clause 1. Secondly, whether the university's administrative circular and the Vice Chancellor's written reminder were a violation of his fundamental right to personal autonomy under Article 5, Clause 1. Thirdly, whether there was a breach of natural justice. And fourthly, whether the arrest of the plaintiff was carried out in accordance with the law. I will be submitting on the first two issues, while my co-counsel will be addressing the third and fourth issue respectively. We both allocate 16 minutes each for our submission and reserve 3 minutes for our rebuttals. My lords and my lady, the plaintiff claimed that Regulation 18 has violated his freedom of speech, which is enshrined under Article 10, Clause 1. However, this right is not absolute. As per Article 10, Clause 2, the fundamental liberty of free speech and expression is subjected to restrictions imposed by the legislature. The restriction in our situation here takes the form of the Sedition Act 1948.
I
In the
think,
case of
counsel, that there is no question about people arguing it is an absolute right. Everybody accepts that there are limitations. The question is there an overreach? If a medical expert is not allowed to express his views, then what next? Is a professor of law not allowed to criticize a law of the country just because he's a professor? So where do you draw the line? Is it an overreach? I think that is more the question rather than whether the rights are absolute or otherwise.
My lord, as a medical expert in his field, if his statements that he has made to the public were of scientific studies, he has shown data, proof that the vaccines are not as efficient as he claims, then he is right to do what he has done, which is release statements of his opinions.
Wait, sorry, I want to clarify your position. So your position is, if his talks were properly backed up, substantiated, right, then Regulation 18 will not apply to him because it is within his rights. Can I clarify that is what you are saying, counsel?
My lord, even though his statements have been backed up, he still has to go through the proper channels to state his opinions through the university, and not just merely going on international seminars and openly expressing his fear.
So it's a twofold test you're saying then. One, first you substantiate it with scientific data and so forth, and then it's the further requirement to go through the appropriate channels of communication.
Yes, my lady.
But he didn't have a chance to substantiate it since you guys did not refuse to listen to his expert witnesses. That is a breach of natural justice, is it not?
My lord, according to the disciplinary committee, is not required to have oral representation. If he wanted to put whatever, if he wanted to back it up with facts, he should have done it in the written representation itself and not ask for oral representation.
So you're saying that he had the right to put in written representations, not just by himself, but even witnesses?
Yes.
But then where would the cross-examination come about?
My lady, it's up to the disciplinary committee to judge, to see whether he has violated against Regulation 18.
But would you agree that it's only from an oral hearing where the other has that opportunity to test out the truthfulness or veracity of the statements made? It can only be derived from an oral hearing. A written representation doesn't give you that benefit.
My lady, although it doesn't give the benefit, he should have tried, if he wanted to, put it in the written submission. And then if the disciplinary committee has any questions to further ask upon it, then they will ask for an oral representation. If he has not put in the facts, the data inside the written submission, there's no point in arguing whether he could have not or could have.
But my reading of Yusof Sudin indicates that the onus is on the committee to first ask itself whether oral hearing is warranted, not for the other side to push for an oral hearing and then to exercise the discretion to hear or not. So the onus is on the committee itself to take the first step. How then do you reconcile your position with Yusof Sudin's position?
My lord, I agree that the disciplinary committee has the right when saying that
obligation to consider whether an oral hearing is warranted.
They consider an oral hearing when there's a need to ask further questions. Otherwise, it's up to the disciplinary committee.
Is what you are submitting in line with Yusof Sudin, counsel?
Are
you familiar with Yusof Sudin because you referred to it in your submissions? Are you familiar with it?
I am not familiar, my lord.
Okay. I don't know how you're not familiar because it appears in your submissions. Never mind, proceed.
In the case of public prosecutor against Wei Kai-shek, a case affirmed by the Supreme Court in public prosecutor against Pung Chen-chu, in this case, Justice Raja Azlan Shah firmly stated in his lordship's view, the right to free speech ceases at the point where it comes within the mischief of Section 3 of the Sedition Act. According to Section 4, subsection 1, paragraph B of the Sedition Act, it is an offense to utter any seditious words. As per Section 2 of the Act, seditious when applied to or used in any aspect of the Act, speech, words, publication, or other thing qualifies as one having seditious tendency. According to Section 3, subsection 1, paragraph D, a seditious tendency is a tendency to raise discontent or disaffection amongst the subjects of Yang di-Pertuan Agong or the ruler of any state or amongst the inhabitants of Malaysia or of any state. If you may direct the court to paragraph 3 of the moot problem on page 3, it can be seen that in the present case, the statement made by the plaintiff, and I quote, insufficiently tested and unreliable vaccines that have been hurriedly prepared by foreign pharmaceutical companies and local distributors with a vested interest in massive profits at the cost of human lives. The plaintiff, who is a renowned medical researcher, made the statements would have an effect amongst the public. The effects of the plaintiff organizing and participating in international seminars indeed have an impact on the Malaysian public. And unfortunately, this is a negative one. Considering that the plaintiff is one, the president of ASA in University Hadri, Malaysia, a public university, and two, a renowned medical researcher, his actions may be evaluated by the public. While the facts are silent on what is actual content of the seminars, we assert that from the beliefs of the plaintiff, it is not too far stretched to say that the content of it is most likely against governmental policy, particularly relating to our public health. We would say it negatively affects the public's confidence in the safety of the vaccine and above all, the government's policy on public health for the benefit of the nation. When a renowned medical...
Shouldn't the fact that he's a renowned medical expert gives him more leeway to express opinions and make comments, even comments that are against the wisdom of the present policies?
My lord, he can make the comments if he can back it up. If he is just merely stating his opinion, this will no doubt disrupt public, as they will feel a renowned medical officer, professor, saying one thing about the vaccines, and while the government, the Ministry of Health, has assured us on the efficacy and the reliability of the vaccines. With that said, we submit to this Honourable Court that application of Regulation 18 by the University was not in violation of the plaintiff's right to free speech under Article 10, Clause 1. My lords, my lady, moving on to the second ground, we contend that the University's Administrative Circular of 23rd December 2020 and the Vice-Chancellor's written reminder of 26 December 2020, on which the second ground of insubordination was based, were not a violation of the plaintiff's fundamental right to personal autonomy under Article 5, Clause 1 of the Federal Constitution. The plaintiff alleges
now,
that the
you have raised in your submissions, I think, you've drawn the equation to employers being able to mandate vaccinations and so forth. But if this was not a contractual term of the employment contract, would this still be possible?
Yes, my lady. This
on
is
what basis?
As per the Occupational Safety and Health Act 1994, requires all employers to take reasonably practicable steps to secure the safety, health, and welfare of persons at work and to protect against risks to safety or health. The employers have a general duty, a duty of care to take care of their employees and their safety.
The availability of online classes, him being a professor and so on, is it in fact necessary to mandatorily vaccinate him?
Yes, my lord.
Fall under OSHA at all?
My lord, could the court please repeat the question?
Would it fall under occupational safety and health if he could carry out his work without being subjected to mandatory vaccination?
My lord, he's the president of the ASA. He has obligations to be at the university. He can't be carrying it out online.
I thought the presidency was separate from the employment.
He has general duties as an employer to the university, and he can't be carrying out his duties as an employee while he's in the house.
I think you have not addressed the question by my learned brother. Principally, lecturers, you have the ability to do so by online methods. This is not an instance where he's a medical doctor necessitating that face-to-face dealing with the public. So wouldn't that have sufficed?
My lady, I contend that it would not suffice because we are moving towards fully vaccinated population where we are able to roam about freely, where we do not need to have mandatory quarantine. We do not have to stay in the house.
Precisely, it is his personal autonomy. If he chooses not to roam freely, chooses not to dine in, it is his choice, isn't it?
My lord, the university needs him as the president. As a medical
university. He's a
president of the ASA. My lord, I do not think I could assist the court at this moment of time. Could I please move on? Thank you. If I may bring to the court's attention, when it comes to basic rights, especially Article 5, Clause 1 of the Federal Constitution, there is a common misconception that personal liberty is a catch-all term. A local classicus on the subject is the case of Pihak Berkuasa against Sugama Balakrishnan, where the federal court observed that personal liberty shall not be generously interpreted to include all those facets that are an integral part of life itself and those matters which go to form the quality of life. The federal court had remarked that the interpretation of personal liberty should instead be restricted to the provisions in Part 2 of the Federal Constitution, which ranges from protection against criminal laws and repeated trials to rights to property. The defendant as an employer have a general duty to provide a safe workplace for their employees. Due to the seriousness of this COVID-19 pandemic, it is reasonable for the university to draft and implement effective policies to reduce the risk related to coronavirus. The plaintiff alleges that the administrative circular is in violation of Article 5, but we would like to put forward to the court the plaintiff has failed to consider the balance between his fundamental right to personal autonomy to the rights of the public. The plaintiff, when refusing to take the vaccination, first of all, sets a bad example as not only an employee, but also a renowned medical researcher, opposing the university's mandate to get vaccinated. The university has the right to mandate vaccination for all the employees, especially where there's a lot of interaction between the employees and the students to prevent a COVID outbreak.
So where do you draw the line? If vaccination is against his religious belief, can you still impose mandatory vaccination?
If the plaintiff has a good reason, like religious belief, then yes, as a religious belief and medical condition. But the plaintiff has no yet proofs of such.
So his conviction is that the vaccines are not properly developed, so he does not want to be vaccinated for fear of his own adverse effects to himself medically. Is it not his rights to refuse vaccination?
My lord, but the Ministry of Health has assured us already on the efficacy of the vaccine, and World Health Organization has approved of the vaccines and its reliability.
See, we are not talking about him making public statements now. We are talking about him receiving vaccination. Does he not have the right to refuse vaccination?
No, my lord, not in this case. As an employee, my lord, if you let me, I would like to cite a case. The case of Nyo Woon Yen against Sungai Wang Plaza Sdn Bhd, the federal court stated, working as instructed is the employee's basic consideration under a contract of employment, just as providing remuneration is the basic consideration of his employer.
My lord, that dealt with the duty to adhere to lawful, reasonable orders, but this is something quite different altogether. Are you saying that as an employee, irrespective whether you have a medical condition or your religious beliefs, the employment rights of an employer supersedes everything else? Is that your submission?
My lords, my lady, I notice my time is up. I would like a minute to answer my lords and my ladies' questions and to wrap up my submission. My lady, could the court please rephrase the question again?
From what you've said, are you then saying the rights of an employer supersedes all else? Because irrespective whether you have religious beliefs, you have a medical condition, too bad. You're my employee. So if I tell you to do this, you do it. You go and get yourself vaccinated.
My lord, my lady, and my lord, we do not contend to that. We are saying that the employee should follow reasonable instructions given out by the employer. And in this case, vaccinations is a reasonable way to safeguard yourself from COVID. If you have a medical condition, then of course, university has no right to force you to get vaccinated. With that, we submit to this honorable court that the administrative circular and reminder were not in violation of the plaintiff's fundamental right to personal autonomy under Article 5, Clause 1. If I may no longer be assistant to this honorable court, I will end my submission. Much obliged.
Thank you, counsel.
Good afternoon, my lords, my lady. May I check if I'm visible and audible? Good afternoon, my lords, my lady. May it please this honorable court. My name is Melvin Ng, the core counsel for the defendants, University Hathari Malaysia and the Government of Malaysia. I will now be submitting on the third and the fourth ground. On the third ground, my submissions will be divided into three parts as to why there was no breach of natural justices on the first defendant's part. The principle of natural justice essentially states that there must be a fair trial and that no one should be condemned unheard. This is where the plaintiffs claim that he should have been afforded an oral hearing and legal representation before the committee comes in, as the principles are implicit in Article 5, Clause 1 and Clause 3 of the Federal Constitution. My lords, my lady, we humbly contend that the absence of an oral hearing and legal representation did not lead to a denial of justice. Our learned friends had stated that following Kumar Guru Sami, the right to be heard must be presumed to exist if the statute is silent on the right of hearing. We submit that the principle propounded in Kumar is inapplicable in the present case before this honorable court, as the statutory bodies specifically provided the right to hearing in the form of written representations. The procedures of the dismissal of a statutory body staff is laid down in Regulation 32, Sub-Regulation 1 of the Statutory Bodies Discipline and Surcharge Act 2000, which states that a reasonable opportunity to be heard must be given before dismissal. It is further provided that the officer under the proceeding is to make written representations within 21 days when the charges are served upon him. Hence,
right. Can I just ask you, given the potential or dismissal here, the fundamental right to livelihood and so forth, your learned counsels have already submitted that he needed witnesses, and this can only be addressed through an oral hearing. So what was the impediment in granting that request for an oral hearing?
My lady, to answer your question, referring to a long line of cases, the federal court had decided, it is stated that the right to hearing does not necessitate an oral hearing. Further, in this case, the committee never stopped the plaintiff from bringing in credible evidence to include in his written submissions.
But the federal court has stated that the disciplinary board must at least consider whether an oral hearing is warranted. And it does not seem to have been the case.
My lord, can I confirm if the case you're talking about is Yusuf bin Sudin?
Yes.
My lord, we would like to submit that the facts in Yusuf bin Sudin is that when there was a request by the public officer for an oral hearing, after he had denied all the charges against him by furnishing credible evidence in his representation letter, then he should be afforded an oral hearing. It can be seen that the plaintiff must first provide credible evidence, and only an oral hearing should be given should the committee think that there is a need of further clarifications.
All right, so you are saying that if I request for oral hearing before giving my written representation, then that's too bad for me. But if I request for an oral hearing after giving my written representation, I'm entitled to an oral hearing. Is that what you're saying?
My lord, that is not what I'm saying. The point we submit is that if the plaintiff has requested for an oral hearing after he has successfully denied on all the charges and providing further clarifications, then the committee, if think that there are any further clarifications needed, the committee may allow an oral hearing. It is not absolute and it is at the discretion of the committee.
But the committee has an obligation to consider whether an oral hearing is warranted, and that does not seem to be the crux of your submission. You seem to have reversed that burden and put it on the doctor to request and substantiate his need for an oral hearing.
My lord, my lady, looking at the nature of the charges framed against him, the charges were not on whether the truth of the statements he made were true, but it was on that whether he had been insubordinate to the university management. So we contend that even cross witnesses and oral hearing is not needed, it's not warranted in this case, because the plaintiff merely has to state and has to provide evidence that he had not the plaintiff only needed to provide evidence to prove his case. That
aren't you going against your co-counsel submission earlier, where he says that if it is substantiated and true, then regulation 18 won't apply? But now you are saying it does not matter. The truth or falsity, it does not matter as long as you have been insubordinate. Are you not taking a position against your own co-counsel?
My lord, can I have a moment?
Of course.
My lord, I would like to bring your attention to the charges framed against him. The disciplinary charges were about the plaintiff making public statements detrimental to the university and government policy and being insubordinate to the university, where he rejected and disregarded the circular and reminder. Even if the plaintiff has proof that his statements made that the vaccines are not safe, it does not, the case does not concern whether he was right in making that statement, but merely it's because he was being insubordinate to the university and he was making public statement that was detrimental to the academic circular.
But if we take your principle all the way, then we are creating an autocratic regime where nobody is allowed to express a view against what is popular opinion of the time. That is a dangerous road to go on, isn't it, Mr. Ng?
My lords, my lady, I agree with your statement. However, as mentioned by my lord, your lordship just now, the plaintiff could have taken another way by dealing with it internally, by talking to the university himself instead of making a public statement without first going through the university. If the plaintiff is able to provide strong evidence that prove that the vaccines are not safe, then the university may take his view into consideration. However, the plaintiff did not do any of this, but instead, he had attended online seminars to make the statement that vaccines are unsafe and in fact and that it is produced by foreign companies without providing any evidence or case to prove his statement. My lord, does that answer your question?
Not really, but never mind. Proceed.
Much obliged. My lord, the principle of natural justice merely necessitates a fair trial, and a fair trial need not include an oral hearing nor legal representation. This was the general principle of cases in this category as confirmed in a recent ruling on this subject matter in Vijayarao against Ruhan Jaya, Perkhidmatan Awam Malaysia. In Vijayarao, the federal court ruled in favor of the dismissed employee and held that the employee was entitled to an oral hearing, as he had specifically requested to be furnished with relevant documents to explain and rebut on the charges orally. We submit that the facts of Vijayarao are only restricted to that category where the plaintiff was able to deny and exculpate himself on all the charges. If I may bring the court's attention to paragraph 8 of the statement of facts on page 4. Is the court with me? Okay, much obliged. The facts of this case are distinguishable compared to Vijayarao, as the plaintiff here did not plead that there was a substantial breach of justice due to relevant documents not being provided to him, but on the case that he was not afforded an oral hearing with expert witnesses and lawyers. My lords, my lady, we cannot see how the plaintiff being heard orally will affect the outcome of the disciplinary trial when the charges against him were framed clearly and no other documents without the plaintiff's knowledge were taken into consideration for the decision of the dismissal. The plaintiff, as a renowned medical researcher and professor who has published multiple academic papers in the past, is clearly well-versed in written communication. Further, the plaintiff was given the chance to explain on all the charges and rebut them with credible evidence if there is any from his side. My lords and my lady, therefore we submit that there is no merit on the plaintiff's claim that there is a denial of justice, although an oral hearing and legal representation were not allowed. My lords, my lady, here comes the second part of my argument for the third ground. We humbly submit to this honorable court that the disciplinary proceedings should not be likened to adversarial proceedings, and the disciplinary authority should be able to formulate its own procedures according to given law. This is supported by the federal court in Lembaga Jurutera, Malaysia against Leong Pui Kun. Further, in Kerajaan Malaysia against Tai Chai Wat, the federal court has stated that the disciplinary authority is the best judge for cases concerning employee dismissal. The court should only interfere should there be a substantial procedural flaw, such as if it can be proven that the decision to dismiss was arbitrary or there was a mala fide exercise of authority. It was further emphasized that courts should not introduce the rules of court to disciplinary proceedings and interfere with the finding of the fact of the committee, citing what Lord Diplock has said in R and Deputy Industrial Injuries Commissioner. It is our contention that it is up to the disciplinary committee whether to allow complicated procedures such as legal and expert witnesses representation. Moreover, there was also no fundamental procedural flaw when deciding the dismissal of plaintiff, and the plaintiff was nevertheless found guilty after the committee had considered the representations. Next, we humbly assert to this honorable court that Article 5 Clause 3 was wrongly pleaded. In the present case before this honorable court, the plaintiff sought to rely on this provision to assert that he should be allowed legal representation before the committee. A plain reading of Article 5 Clause 3 would indicate that a person who is arrested is required to be informed of the grounds of arrest and be allowed to be consulted and be represented by a legal practitioner. However, the plaintiff was neither arrested nor detained before the disciplinary committee. Hence, we submit to that the plaintiff cannot invoke this clause to plead that he was not given the right to legal representation. And there was no violation of principle of natural justice as to that plea. My lords, my lady, I will now delve into the submission for my fourth issue. For the first claim, I will explain why the emergency ordinance in question, Emergency Essential Powers Number 2, Ordinance 2021, was still in force at the material time when the plaintiff was arrested and detained. The federal constitution laid down two methods where an emergency ordinance can be revoked. The first method is prescribed under Article 150 Clause 3, where the ordinance can be revoked once the Dewan Rakyat and Dewan Negara pass a motion to annul the ordinance, which effectively revoke the ordinances. And the second method would be revocation by the king when the emergency is still ongoing. The plaintiff claimed that the cabinet brought the emergency ordinances to an end on 21st July following a statement made by the then Minister of Law. My lords and my lady, Article 150 Clause 3, when read together with 150 Clause 2A, stated that the king has the authority to revoke the ordinances promulgated. It is acknowledged that Article 40 Clause 1 stated that the king is to act on the advice of the cabinet. However, the revocation must still be made by His Majesty. According to the federal constitution, the king who acts on the advice of the cabinet revokes the ordinances. This is
the cabinet has already decided to revoke, but the cabinet, for reasons of its own, did not put it up to the king. And therefore, there was no revocation by the king. Neither did the cabinet table it before parliament. And therefore, there was no revocation of parliament. So it seems like the government is trying to benefit from its own omission, isn't it?
Yes, my lord.
And they are permitted to omit to benefit from their own omission?
No, my lord. I'm trying to contend that the emergency ordinances were never revoked, even though the then Minister of Law has come up with a statement that the emergency ordinances had been, the king has already given his consent to revoke the ordinances.
Precisely. It has not been revoked according to the two ways that you have put forward. However, it is the government's own omission that resulted in the non-revocation, isn't it? So how can the government now in this court seek to benefit from its own omission?
My lord, I believe there was a miscommunication between the then Minister of Law with the king, because the Istana Negara has
That
come
is
up.
not within your knowledge, counsel. Surely you are submitting from the bar on this.
Yes, my lord. However, in this case, we believe that by proving that the emergency ordinances were never revoked would help in our case. Therefore, it is our contention that the emergency ordinances were still in effect when the plaintiff was arrested and detained. With that, I will move on to my second limb of my argument for the fourth issue. In the event where the arrest and detention are found to be in violation of the clauses mentioned for any reason by this honorable court, we would like to raise Section 27 of the Emergency Ordinance as a defense, where the provision states that the government or the police officers are protected from being sued as long as they were enforcing the provisions under this ordinance in good faith.
Is there any difference, the fact that the plaintiff is merely seeking declarations? He is only seeking declarations from the court as to his rights. He is not in fact seeking any other remedies from the government. Is there a difference?
Yes, my lord. There is a difference between the plaintiff seeking his declaration and remedies for the default done by the police officers. However, we would like to contend that the police officers on duty had bona fide belief that the ordinance suspended fundamental rights under the Constitution, and that the arrest, detention, and the refusal of the plaintiff's request to consult a lawyer were carried out in accordance with provision of the ordinance, which can be seen when the police officers cited the provision in good faith. My lords, my lady, I see my time has lapsed. Can I have a minute to sum up my submissions?
Yes.
Hence, we humbly submit that even if there was any act, neglect, or default done by the police officers when carrying out their duties under the ordinance, the proceeding shall not be instituted and maintained in this honorable court for that reason. If I may no longer be of assistance to this honorable court here, I would end my submission. Much obliged.
Thank you, counsel.
The Honorable Court is now adjourned. Counsel may now leave the breakout room to allow the judges to deliberate.
No rebuttal.
Oh, right. There's a rebuttal session. Sorry.
Oh, who's supposed to do rebuttal?
Oh, okay. I thought, okay. May it please the court. My lords and my lady, I have 4 rebuttals. First, we respectfully disagree to my learned friend who has started
Sorry, I can't hear
stated that the
you.
Ministry of Health has proved. Am I audible, my lady?
Now you are, but I couldn't hear you just now. So maybe you can start again, please.
Much obliged. May it please the court. I have 4 rebuttals. First, we would respectfully disagree to my learned friend who has taken the vaccine. This is merely an assumption.
I'm
Am I
sorry,
audible?
but I can, due to these technical difficulties that my co-counsel is facing right now, I would do the rebuttals on behalf of her. My lady, I would like to begin the plaintiff's rebuttals. I have 4 rebuttals to submit. We would respectfully agree to my learned friend who stated that the Ministry of Health has proven the efficacy of the vaccine. This is mere assumption. Therefore, when there is no proven efficacy from the government, it is reasonable for plaintiffs, being a renowned medical researcher, to tell the public about the vaccine, and it is also within the freedom enshrined under federal constitution. The right of an employer does not supersede all, but the federal court supersedes all law that is in violation of the constitution. The court should rely, third ground, the court should rely on the federal case of Vijaya Rao and A.L. Subramaniam and Surhan Jaya Perkhidmatan Awan, Malaysia, that was decided on August 2018 and ruled in favor of the plaintiff because the law as currently adopted is more inclined to favor of affording the right to being heard orally by an officer facing disciplinary proceeding if there is a request made by him. Pursuant to Article 150, Clause 6, it says that fundamental liberties guaranteed under federal constitution were not superseded because the suspension was not expressed in the emergency ordinance or act of parliament. And I would like to heavily emphasize on this point that the plaintiff was already been dismissed. He was also not allowed to be represented by a lawyer during his detention. My lady and my lord, the treatment given to him was too harsh, and the emergency ordinance shouldn't be a blanket to restrict the plaintiff of his fundamental liberties. So I would end my rebuttals here, my lord and my ladies. Much obliged.
My lords, my lady, now I will answer to the rebuttals. In regards to the submission that we cannot assume the efficacy of the vaccine and that the plaintiff had the right to inform the public of the vaccination inefficiency, we would like to submit that this is against the law that grants freedom of speech and expression, because the plaintiff, as a medical renowned officer, his words carry weight. And if he cannot prove that the vaccines are not safe and are not efficient with credible evidence, with reports, it will create chaos in the society. For the third rebuttal, the plaintiffs requested that the court adjourn in favor of them because following the case of Vijaya Rao, the court would be more inclined to grant an oral hearing. However, we would like to submit that this right is not definite and it's not absolute. I'm sorry, my apologies, it's not definite because the committee had the right to say that you did not provide credible evidence for us to require further clarifications. Therefore, an oral hearing is not needed. As for the fourth rebuttals, where the plaintiff has submitted that fundamental liberties cannot be restricted if there is no express provision given, we agree with the plaintiff's counsel. However, Section 27 of the ordinance should exclude the government of Malaysia from proceedings in this court. Here I will end my rebuttals. Much obliged.
Thank you, counsels.
All right, the Honorable Court is now adjourned. Counsel may now leave the breakout room to allow the judges to deliberate. Counsel will be informed to re-enter the breakout room after the deliberation for a feedback session. Thank you. Judges will be given 15 minutes to deliberate. Thank you very much, everyone.
Thank you. All right, are we the only ones left? How come Suganti also left?
Just a moment, Mr. Kang Ho. I think she's having technical difficulties.
Okay, okay.